Good morning, everyone. Happy Supreme Court Opinion Day, or unhappy Supreme Court Opinion Day, whichever side you come down on that. Good morning, everyone. We're going to get one or more decisions from the United States Supreme Court. Thank you, Loco Fiesta. In 20 minutes. So we're going to talk through the cases that could be coming up, and we'll find out together which opinions we get. The Supreme Court is also hearing oral argument this morning. I think there's a lot of activity going on. I got a lot of emails in my inbox about different events and protests that are going on outside the court related to today's case about Medicaid and Planned Parenthood. So that may be an interesting one you want to listen in on after we do opinions. Today's case is out of South Carolina, the oral argument, not the decision that we're getting. And it's about whether states basically can remove Planned Parenthood of Medicaid funding because they provide abortions. So that will be the oral argument that comes up right after opinions. We will do opinions together. That happens right at 10 a.m. The justices take the bench right at 10 a.m. and they announce one or more opinions. Simultaneously, the press office receives physical paper copies right at 10 a.m. and then they upload the opinions right at 10 a.m. on the Supreme Court's website. So lots of things happening at one time. And shortly after opinions, that's when they'll do the oral argument in the Medicaid Planned Parenthood case. But I think lots of people are there at the court right now. Colleen, I'm not sure what you're saying, wait, what about? But I can re-explain something if it's helpful. They're hearing the Medicaid Planned Parenthood case today, yes, out of South Carolina. Basically, whether they can exclude Planned Parenthood services from the state's Medicaid program and whether there's even standing to sue to enforce the Medicaid Act. What are the oldest cases we are waiting on? That is a great question. So, if you're curious about which ones have been decided and which ones haven't, SCOTUSblog has, first of all, the live blog going up in 4 minutes, but also we have a list of all of the cases that have been argued this term and which ones have been decided. There are even links, and you can click on the opinions for each of the decided cases and the background and our coverage for each of the cases that have not yet been decided. So from the October sitting, we got last week one of the bigger ones we've been waiting on about ghost gun part kits, where the Supreme Court said that those qualify, in a 7-2 decision, those qualify ghost gun part kits or privately made gun part kits, qualify as firearms under federal law that regulates firearms, such that means that the ATF can require makers of these part kits to follow the same rules as federally licensed gun dealers, which includes things like record keeping and background checks, serial numbers, things like that. So that was the oldest one that we were waiting on until last week. Now we have one left from the October sitting, which is when the term begins, first Monday in October. And that's the medical marijuana v. Horn case. It's a RICO case about suing under RICO, but it's about this guy who was a truck driver who took CBD products thinking they didn't have THC in them, and the company told him that they didn't have THC in them, but turns out they did, and he failed a drug test and he lost his job. And the question is whether he can sue under RICO, which allows you to get triple damages for injuries to business or property by reason of the defendant's acts. That's kind of the text of the statute. So that's now the oldest to answer the question of who, I don't remember who asked it, but what's the oldest case we're waiting on? That's it. That's the only one left from October that has yet to be decided. So they're moving and grooving with the October cases. And we have a good number of decisions out of the November sitting as well. So we're still waiting on a Medicare Act case. We are waiting on... this is about counting on a calendar because that matters in litigation when things are due and what counts as a complete day. So the question in this case from the November sitting, Velasquez v. Garland, which now would be Velasquez v. Bondi, whether and when a non-citizen's voluntary departure period ends on a weekend or public holiday, a motion to reopen filed the next business day is sufficient to avoid penalties for failure to depart. Anyone in litigation will tell you that sometimes counting the due date of a brief or a deadline can be its own nightmare when you count weekends and holidays and what counts as a holiday and the next business day, and is it business days or is it real days, all of those things. So that's an interesting one. Yes, Spork, we are getting at least one opinion today. So that's it. We're only waiting on 2 from the November sitting. And then into December, we have the e-cigarette case. The FDA denied these companies the ability to make new e-cigarettes, and the question is whether that was arbitrary and capricious. That one could be an interesting one. We could get that today, possibly. What else are we missing from Scrimeti? We're missing from December. I don't know that we would get that today. That's about the Tennessee bill that bans gender-affirming healthcare for trans minors. I know a lot of you are keeping a close eye on that one. That was argued December 4th. There's a criminal law case. Department of Transportation case, whether a federal civilian employee called or ordered to active duty under a provision of law during a national emergency is entitled to differential pay, even if the duty is not directly connected to the national emergency. We're waiting on a NEPA case, the National Environmental Policy Act, that requires pretty much anyone to do environmental impact assessments when they're building or doing new projects that could affect the environment. So there's a question there about that law. And then from the January sitting, so we have two from November we're waiting on. From December, we have a total of 1, 2, 3, 4, 5. So a lot from December. And then from January, we had the TikTok case. That was decided very quickly. We're waiting on a case about the First Step Act. The First Step was signed by Trump during his first administration that allows certain sentences to be reduced. So there's a question about the application of the law in that case. That'll be an interesting one. We've got an ADA case, Americans with Disabilities Act. I'm just seeing that our social media is pushing out that the opinion announcement on SCOTUSblog, live blog, is live now too, so you can watch that there. We've got an ADA case, American with Disabilities Act, that was argued January 13th. A couple of cases have already been decided. 3 cases have already been decided from January if you count the TikTok case. We've got the case about, was that January? Yeah, Texas's age verification law for porn websites, that you have to verify your age using some sort of government issued ID or some other way. there was some factual dispute there about what the method of verification was. But that case was argued in January, so that could be one that we get now. That was argued January 15th. Yeah, there's a question about jurisdiction in an FDA case. There's a Hobbs Act question. I'm sure there's some Hobbs Act nerds on here. That was argued in January. It's possible we get that one. Let's see, what else do we have? Looking at excessive force claims under the Fourth Amendment. Whether courts should apply the moment of threat doctrine when evaluating an excessive force claim. That one will be an interesting one. And then pretty in the weeds statutory interpretation case from January. So I don't think we have 3 decisions from January, but the bulk of the cases we don't have decisions from January. Any updates on the emergency docket, Jared asks. Actually, moments ago, we just got the SIR reply in the challenge from the Trump administration asking the court to get involved and stay the lower court's TRO in the Alien Enemies Act case. So the Alien Enemies Act is the authority that the Trump administration is invoking to detain. It provides wartime authority to detain and deport individuals who are in the country from an enemy nation or government. It's only been used 3 times in history, the War of 1812, World War I, and World War II. They're using it now because they say that the Venezuelan gang, Tren de Aragua, has basically affected a predatory incursion or an invasion in the United States, and they need to act. So the tripwire, basically, to the requirement for the president to invoke this authority is that we either be at war or there be a predatory incursion or an invasion. So they're saying there's a predatory incursion and invasion from Tren de Aragua. They're deporting all of these individuals from Venezuela that they say are members of the gang. There's some question about whether these individuals are getting or got due process at the time that people were very quickly put on planes and sent to El Salvador. And for some of you who are following that case, I'm sure you saw, the judge is the chief judge of the DC District Court. He ordered them to stop all of these deportations, including turning the planes around that were in the air on their way to El Salvador. They didn't turn the planes around. At least one plane with people who were deported under the Alien Enemies Act landed in El Salvador, and people are there. Interestingly, in Maryland yesterday, because I also do local news here, there was a man who was, the government said, mistakenly deported to El Salvador. There's a question of whether he was a Title VIII deportation or Title VIII and Alien Enemies Act or what have you. But it wasn't so much that he wasn't allowed to be deported. He was deportable or removable. It was just that there was a court order saying he couldn't be removed to El Salvador. Anyway, the Trump administration has gone up to the Supreme Court and said, you've got to get involved here because this judge is basically intruding on the president's powers to deal with foreign affairs and national security, which is what he's trying to do with deporting these individuals. And so the court will decide whether or not they're going to issue a stay of the district judge's order. The DC Circuit refused to do that after holding oral argument. We'll see what the Supreme Court does. But that basically, when you make an emergency request at the court, your emergency request goes up, they call for a response from the other side, and then typically the original side gets what's called a SIR reply that they usually file within 24 hours of the reply, which is what happened. So now it's considered fully briefed, and the court could decide at any time. So we'll see what they do. Somebody's asking me what our box count is for today. Let me see if Amy has it. Somebody on the live blog wants it to be a 7-box day. That would be aggressive for all of us. We don't have a box count yet. People think Justice Barrett perhaps has the medical marijuana case, which may be right. Somebody on the live blog is asking what it means for a case to be fully briefed. That's kind of what I was just explaining with the emergency request, at least. Okay, what else can so we've walked through some of the potential cases that we'll get. The court is hearing oral argument at 10, well, a few minutes after 10, good morning, Connie. A few minutes after 10, once we get opinions. That will be live, so you can live stream the audio there. Somebody asked me this last time. What is the highest number of boxes you've seen? Maybe 4? Amy was answering this question in the live blog too, but I'm not 100% sure. For those who don't know what the box count is, that's the physical paper copies that are delivered in the Supreme Court press office on an opinion day. So while the justices take the bench, typically members of the press are up there and getting ready to hear oral argument. But if they want to be able to communicate with the public, like we do on TikTok or on Twitter or on the live blog or what have you, you don't get to be inside the courtroom because you can't bring your phone in the courtroom. So you have to be in the press office, and the press office provides you with physical paper copies right as the clock strikes 10. We literally all gather in the press office, which is tiny. And everybody waits for the clock to strike 10, and then we rush and grab the paper and run back to our seats and then hopefully communicate to the public. So it has gotten exponentially better now that they also simultaneously upload the documents online, or at least more transparent. But that's where the box count comes from. The press office right now is probably walking to their desk with boxes or a box of whatever opinions we have for the day. And so sometimes we use that to discern, is it going to be a heavy opinion day if we have 2 or 3 boxes? Amazon Rainforest correctly says it's 1 box. You guys are also watching the live vlog at the same time. Amy just confirmed 1 box today. So perhaps 1 to 2 opinions, or 2 opinions and a dig. I don't know. We could get all kinds of different combinations. What's my guess on what we'll get? That's interesting. I think it's certainly conceivable we get the medical marijuana case today from October. Maybe the Velasquez case about counting for a non-citizen's voluntary departure period when that ends. That's feasible. And I don't know that we'll get Scarametti yet, or the Texas porn law case. Yeah, I don't know. So we have just about 3 minutes until we all find out together. The Supreme Court does speak when they release opinions. They have accidentally opened up the audio for that before, so you could try and listen, but typically they don't. What arguments are they hearing today? So right after opinions, they're hearing an argument in a case that has drawn a lot of attention. The case is about whether South Carolina can exclude Planned Parenthood from Medicaid. But the court's decision, of course, will apply much more broadly to all states and whether they can restrict Planned Parenthood from being part of Medicaid. They're basically trying to strip Planned Parenthood of Medicaid program because it provides abortions. So there's lots of challengers up there. Any tips for someone who is considering going back to school to be an attorney? Being an attorney is the marvelous, wonderful thing. Law school can be a marvelous, wonderful, terrible, cruel thing. Go to office hours. I would say go to office hours as much as you can with every professor. That will help because you don't get everything you need in the classroom. You just don't. Will what decision be announced this year? Yes, the Medicaid one. Yes, it will. That one will probably be closer to the end of June because it's just getting argued now in April. Network with your law school colleagues. That's another good idea. Okay, so 9:59. Time to go to the Supreme Court's website, supremecourt.gov. If you're new here, and then click opinions in the top left and opinions of the court, or don't do any of that and just wait and I will walk you through it. Oh, that's great. Congrats. I'm so glad. Yikes, how many cases has Trump put before SCOTUS? I don't know the answer to that one. That would be a good one for someone to count. All right, it's 10 a.m., so I'm going to start hitting refresh over and over and over. A couple of things if you're on the Supreme Court's website and if you're listening to me, I'll know right away if it's the only opinion of the day because we will get a number in the R column on the left-hand side of the screen on the Supreme Court's opinions page. I'll tell you if it's the final opinion of the day. I'll tell you when it's the final opinion of the day. And on the right-hand side, you see a J column, and that is the justice who's writing the opinion. On opinion days, opinions are released in order of reverse seniority of the justices. I was right. We got medical marijuana. I never get that right. And it's not the final opinion of the day. It is Justice Amy Coney Barrett. Man, we're getting so many things right in our guesses today. All righty, let's see. This is the case about the truck driver. Under Civil RICO 1964C, a plaintiff may seek treble damages for business or property loss, even if the loss resulted from a personal injury. So that is a win for the truck driver. Justice Barrett delivered the opinion of the court joined by Sotomayor, Kagan, Gorsuch, Jackson. Jackson filed a concurring opinion. Thomas dissented. Kavanaugh dissented. Roberts and Alito joined Kavanaugh's dissent. So that is 5-4 with Barrett and Gorsuch joining the liberal justices in the majority. RICO creates, I'm reading briefly from her decision, creates a cause of action for any person injured in his business or property. We must decide whether the statute, by implicitly denying a remedy for personal injuries, also denies a remedy for business and property loss that derives from a personal injury. It does not. In 2012, Douglas Horne was working as a commercial truck driver when he crashed his truck and injured his back and shoulder. Months later, he was still suffering from chronic pain, and neither physical therapy nor traditional medicine provided relief. While searching for a natural alternative, Horne came across Dixie X, a tincture infused with cannabidiol, with THC, or CBD actually, sold by Medical Marijuana Inc. CBD is like its cannabis cousin, tetrahydrocannabinol, THC, which is a naturally occurring chemical compound found in the cannabis plant. Only THC, however, has the mind-altering properties associated with marijuana. Because a positive drug test could cost him his job, Horne was wary of any product that might contain THC, but Dixie X seemed safe. It was described as CBD-rich, non-psychoactive medicine that is 0% THC. Medical Marijuana's online FAQ page promised that Dixie X was legal to consume both here In the US and many countries abroad, additional research, including a call to customer service representative, reinforced those representations. Satisfied that Dixie X was THC-free, Horn bought a bottle and gave it a try. A few weeks later, Horn's employer selected him for a random drug screening. To his surprise, the test detected THC in his system. After Horn refused to complete a substance abuse program, in his view, doing so would constitute an admission of doing drugs, his employer fired him. Horn then ordered another bottle of Dixie X, sent it to a third party for lab testing. This test also came back positive for THC. In fact, the lab refused to mail the sample back to him, fearing doing so would violate federal law about mailing marijuana. Let me just go back and make sure we don't have the second opinion yet. We do not. I'm going to keep reading this. This is a win for the truck driver who took what he thought was only CBD, but the company lied to him and it was THC, and he got drug tested and he got fired. But now he can sue them under RICO for triple damages. Horn sued medical marijuana in federal district court, raising a civil RICO claim, as well as a host of other state law claims that aren't relevant to this case. He alleged that medical marijuana was a RICO enterprise engaged in marketing, distributing, and selling Dixie X. You have to be a criminal enterprise to come under RICO. He also asserted that medical marijuana's false or misleading advertising satisfied the evidence of mail and wire fraud, and that those crimes constituted a pattern of racketeering activity. Quite creative. The district court granted summary judgment to medical marijuana on the RICO claim. According to the court, Horn's lost employment flowed from and was derivative of a personal injury he suffered, the introduction of THC into his system through the ingestion of Dixie X. Yet, RICO's civil cause of action, the court stressed, is available only to a person injured in his business or property. Because a plaintiff cannot recover for a personal injury, it reasoned, neither can he recover for a business or property harm that results from a personal injury. So for Horn, that offered no path for relief. The Second Circuit reversed. It began by analyzing the issue that neither the district court nor the parties had addressed, whether the term business in 1964C encompasses not only a commercial or industrial establishment or enterprise, but also an individual's employment. Adopting the broad definition, the Second Circuit concluded that Horn had been injured in his business when he lost his job. It turned to the district court's holding that a plaintiff like Horn cannot recover for a business or property harm that flows from an antecedent personal injury. Horn insisted that any personal injury bar was inapplicable because the court had mischaracterized an unwitting ingestion of THC as a personal injury from which his employment loss derived. But the Second Circuit put this issue aside, instead holding that RICO does not impose an antecedent personal injury bar. It acknowledged that by granting recovery to someone injured in his business or property implicitly excludes recovery from personal injuries. Even so, the court said nothing in RICO's text or structure justifies reading this negative implication to include recovery for all business and property injuries that happen to derive from a personal injury. Rather, Congress expressly authorized a plaintiff to sue for injuries to his business or property. Blah, blah. By rejecting an antecedent personal injury bar, the Second Circuit deepened a split among the circuits. The 6th, 7th, and 11th circuits have each interpreted RICO to preclude relief from an economic loss, including loss to business or property that results from a personal injury. The Second Circuit has joined the 9th Circuit in refusing to distinguish between a business or property loss suffered from an immediate consequence of a RICO violation and one derived from or a secondary effect of a personal injury. We granted cert to resolve the split. Hang on, let me check to see if we have the other decision yet. We do not. When all is said and done, this is from Amy in the chat reading from Barrett's opinion. Medical marijuana is left fighting the most natural interpretation of the text, that injured means harmed with no plausible alternative in hand. That is a battle it cannot win. She notes that RICO's direct relationship requirement is a constraint on civil RICO claims. In particular, she notes because of the number of steps in Horn's theory and the multiple actors involved, this requirement may present an insurmountable obstacle in his case. Indeed, even Horn concedes that he faces a heavy burden on remand when he continues to pursue this claim. She also acknowledges that civil RICO has evolved into something quite different from the original conception of its enactors, but that is a problem for Congress, not the courts, she concludes. Justice Thomas indicates that he would have dismissed the petition as improvidently granted, otherwise known as a dig. So the truck driver wins, who accidentally ingested THC thinking that it was just CBD in order to help with pain that he was managing from being in an accident years before. Justice Thomas says that the court should save the question for a case where all agree that the plaintiff suffered a personal injury and where a resolution of the question will unambiguously matter. Amy is saying Justice Barrett is still reading from her opinion from the bench. The justices can read from their opinion or add commentary from the bench when they deliver it. So it might be a moment, especially if any of the dissenters are going to speak as well. So let's go back to the opinion, shall we? Blah, 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 blah. I'm just trying to get to the good stuff for you guys. So just to be clear, the personal injury, or what is debated as the personal injury, is his ingestion of THC, which the district court said that's a personal injury. Civil RICO doesn't cover that. The Second Circuit said, yes, if you were injured to your business or property by reason of the defendant's actions and it's derived from the personal injury, then it's okay. This is a 60 pages worth of text, 61 PDF pages worth of text from the court. And the reason why RICO can be particularly burdensome is you have to show an orchestrated criminal enterprise, which takes a lot of effort and a lot of evidence and facts on your side. Looks like maybe we got the second opinion. Somebody's saying FDA. Yeah, FDA, fee wages and white line investments. What a banner day at the Supreme Court today. Okay, so this decision is delivered. Okay. Justice Alito delivered the opinion of the court. It is unanimous. Justice Sotomayor filed a concurring decision. So this is about whether the Court of Appeals here erred in setting aside the FDA's orders denying applications or authorization to make new e-cigarette products as arbitrary and capricious. So the holding summary is somewhat complicated. As a preliminary matter, the court declines to reach and thus expresses no view on respondents' argument that the FDA erred in evaluating respondents' applications under standards developed in adjudication rather than standards promulgated in notice and comment rulemaking. This complicated question sweeps beyond the question presented and lacks adequate briefing. The Fifth Circuit's conclusion that the FDA acted arbitrarily and capriciously in its adjudication of manufacturers' pre-market tobacco product applications is vacated because the FDA's denial orders were sufficiently consistent with its pre-decisional guidance as to scientific evidence, comparative efficacy, and device type, and thus did not run afoul of the change in position doctrine. The court agrees with the FDA that the Fifth Circuit read Calcutt too broadly. That said, the proper standard presents a difficult problem requiring reconciliation of the so-called remand rule developed, blah, blah, blah. Okay, let's get to the opinion. This case concerns the efforts of the FDA to regulate the sale of e-cigarettes, a product that rapidly gained popularity during the past 20 years. The governing federal law, the Family Smoking Prevention and Tobacco Control Act of 2009, restricts the sale of all tobacco products that were not commercially marketed in the United States before February 15, 2007. Unless otherwise authorized, a manufacturer may not introduce such a product to the market until the FDA determines that it is appropriate for the protection of the public health. So you have to basically prove to the FDA if you want to make a new e-cigarette product post-2007. In this case, we consider whether the FDA lawfully denied authorization to market certain flavored e-cigarette products. So they're vacating the Fifth Circuit's decision and sending it back basically for a redo, and they're clarifying the legal standard that applies here. But let's dig into it a little bit more. One of the FDA's longstanding responsibilities and it's a unanimous opinion, and this is the final decision of the day. One of the FDA's longstanding responsibilities dating back nearly a century is to determine whether manufacturers may market new drugs. For much of that history, the FDA lacked jurisdiction to regulate tobacco products. By the time Congress conferred that authority, because big tobacco had a very strong lobbying in Congress. By the time Congress conferred that authority in 2009, a new product was ascendant on the market, the e-cigarette. The product offers existing smokers a potentially safer alternative to traditional combustible cigarettes. But e-cigarettes carry their own health risks, and they come in a dizzying array of flavors, many of which, such as dessert, candy, and fruit flavors, are particularly appealing to the young. The surging youth demand for flavored products and the prospect of a new generation of smokers caught the FDA on its back foot. That's a nice sentence. In 2016, the agency declared that manufacturers of e-cigarette products would need to obtain the same marketing authorization that is required for other tobacco products. The FDA's regulatory efforts culminated in the 2021 denial of over 1 million applications for flavored e-cigarette products. The dispute before us arises out of that mass denial. The Pure Food and Drug Act of 1906 was Congress's first foray into the comprehensive regulation of food and drugs. The act prohibited interstate blah, 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 blah in 1938, blah, 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 blah. By the middle of the 20th century, blah, blah. The FDCA was enacted long before public awareness of the dangers of smoking became widespread, blah, blah. Tobacco regulation was largely left to Congress. Again, because they had strong, powerful lobbyists. Against that backdrop, Congress enacted the Family Smoking Prevention and Tobacco Control Act of 2009. It vests the Secretary of Health and Human Services acting through the FDA with the authority that this court previously found lacking, namely the power to regulate the manufacturing, marketing, sale, and distribution of tobacco products. Blah, blah. The TCA's reach was broad. One pathway to authorization of the sale of a new tobacco product is the submission of a pre-market tobacco product application. These applications require, among other things, information about a product's components and additives, the method by which it is manufactured, and any proposed labeling, and an assessment of its health risks. There are many reasons why the FDA may deny marketing authorization to a new tobacco product, but of main importance here, the agency must deny an application unless it is shown that the product would be appropriate for the protection of the public health. So part of the argument here from the makers is that this is a healthier alternative to regular cigarettes. To determine whether a product meets this standard, the FDA must consider all of these things, blah, blah. The FDA must act as promptly as possible on pre-market tobacco product application and in no event later than 180 days. At the end of the 20th century, tobacco manufacturers tried, without much luck, to market safer alternatives, blah, blah. Man, this is a winding opinion here. The impetus for the invention of the e-cigarette was the desire to create a product that would reduce the health risks of smoking. E-cigarettes I'm skimming through the opinion. E-cigarettes typically come in either a closed or open system. Oh yeah, there was talk about this at oral argument, the types of e-cigarettes. Somebody asking a fair question. There's nothing in our Constitution regarding smoking. Why are they addressing it? Well, first of all, they also address questions about the interpretation of federal law, not just the Constitution. And this is the interpretation of this Family Smoking Health Prevention Act that gave Congress the authority to regulate manufacturers and the sale of tobacco products. So they're conducting a statutory interpretation of this law because there was a challenge to how the FDA was interpreting it. And that's why they're addressing this question. There's fierce public debate about the potential benefits and harms of e-cigarettes. On the one hand, many view e-cigarettes as a harm reduction tool. They enable current smokers who are addicted to nicotine to reduce exposure. On the other hand, e-cigarettes, as noted, pose their own health risks, blah, blah. Youth demand is a problem. To give these manufacturers adequate time to apply for pre-market authorization, the FDA delayed enforcement for 2 to 3 years. This gave e-cigarette products time to remain on the market while manufacturers filed their applications. At the center of this case are the FDA's actions leading up to its adjudication of manufacturers' pre-market tobacco product applications. The agency proposed a rule outlining application requirements, issued guidance. Pervading these documents are four overarching topics that animate the dispute before us. It's taking a long time to get to the meat here. The first topic was the type of scientific evidence needed to show that the e-cigarette product is appropriate for the protection of public health. The second topic was the need for manufacturers to compare their proposed products to other products. That's like current cigarettes or regular cigarettes. In a lengthy April 2020 guidance document, the FDA elaborated on the third theme. Its enforcement priorities based on device type. The agency said it would prioritize enforcement of flavored cartridge-based e-cigarette products other than tobacco and menthol flavored products. It claimed that youth overwhelmingly prefer cartridge-based products, which are easy to conceal, can be used discreetly, and may have high nicotine content and are manufactured on a large scale. The final theme cutting across these documents, these applications, is the FDA's unflinching advice that manufacturers should submit marketing plans as part of their applications. In 2019, the FDA proposed a rule setting out the requirements for pre-market tobacco product applications that crystallized the four themes. Notice and comment rulemaking takes time, and with a court-imposed deadline fast approaching, the FDA proceeded to adjudicate the first major wave of pre-market tobacco product applications in August and September of 2021 without a final rule and the standards it included. When you make a rule as an agency, it has to go through notice and comment, meaning the public gets an opportunity to provide feedback before the rule becomes final. So they made decisions on these applications before the rule was finalized, including the standards that would be imposed for these applications. It was not until October 2021 that the FDA adopted the final rule. Respondents, the Wages and White Lion Investments, doing business as Triton Distribution, and Vapetasia, manufactured flavored e-liquids for open system e-cigarettes. Their e-liquid flavor offerings include Killer Custard Blueberry. This is the best part of the decision. Killer Custard Blueberry, Rainbow Road, Iced Blackberry Lemonade, Pineapple Express, Suicide Bunny Mother's Milk and Cookies. I don't know what that's a reference to, but that seems like a weird vape flavor. And Blueberry Parfait. Suicide Bunny Mother's Milk and Cookies? What is that from? Does anybody know that? Okay. Respondents submitted pre-market tobacco. DM me if you know that, because I'm curious. They submitted these pre-market tobacco product applications September 2020. The FDA received applications from more than 500 companies in total. I'm skimming here still. Shortly thereafter, the FDA denied respondents' applications. It concluded that respondents had not provided sufficient scientific evidence to demonstrate that the marketing of their products would be appropriate for the protection of public health. Specifically, the FDA held respondents had not provided evidence from a randomized controlled trial, longitudinal cohort study, or another reliable and robust method showing that their dessert candy fruit flavored products have benefits over an appropriate comparator tobacco flavored product. With such evidence lacking, the FDA deemed respondents' products misbranded and adulterated under the FDCA. To each denial order, the FDA amended the technical project lead title review from the rule. Despite the FDA's prior representations about the importance of marketing plans, the reviews stated that for the sake of efficiency, the FDA had decided not to evaluate respondents' marketing plans. The FDA estimates that in its first wave of marketing orders, it issued denials to 320 applicants who sought approval for approximately 1.2 million products. Respondents petitioned for review in the Fifth Circuit. The court reheard the case en banc. In a footnote, the en banc majority also suggested the FDA had violated a provision of the TCA's notice and comment requirements by imposing a de facto ban on flavored e-cigarettes through mass adjudicatory denials. The en banc Fifth Circuit's decision conflicted with the other circuits. We granted the FDA's petition for writ. We now vacate and remand. This comes on page 23. Now we get to part 2 of the decision. The question we agreed to decide is whether the FDA acted arbitrarily and capriciously in denying respondents' applications for pre-market approval of their tobacco products. But before tackling that question, we briefly address as a preliminary matter an argument that is touched on in respondents' brief, namely that either the APA, Administrative Procedure Act, or the TCA required the FDA to use notice and comment rulemaking to set out the requirements that must be met in a pre-market tobacco product application. Unless Congress has specified otherwise, agencies are generally free to develop regulatory standards either by general legislative rule or by individual order. Blah, blah. We did not grant cert on that question. Without adequate briefing, it would not be prudent to decide it here. Accordingly, we do not reach that question and express no view on its merits. They're not dealing with the notice and comment rulemaking alleged violation. We now turn to the Court of Appeals holding that the FDA acted arbitrarily and capriciously. That decision was multifaceted, but its analysis boils down to a central concern. It faulted the FDA for allegedly changing the requirements for pre-market tobacco product applications between the time of its guidance and the denials of respondents' applications. The feature of our current case law on arbitrary and capricious review that addresses that issue is our change in position doctrine. I'm sure you guys got jokes about that. Under that doctrine, we must ask whether the FDA changed course, and if it did, whether it offered satisfactory reasons for that change. SCOTUS dog is barking. So basically, whether the FDA changed course. Analysis of the FDA's position prior to the denials at issue requires a close reading of nuanced statements and a body of guidance documents that evidence the agency's evolving assessment of the relevant issues. Affected parties may have come away with the impression that the agency would apply a less demanding standard of proof than is evident in the denial orders the FDA ultimately issued. But in the end, we cannot say that the FDA improperly changed its position with respect to scientific evidence, comparative efficacy, or device type. With respect to the FDA's guidance on marketing plans, we clarify the appropriate legal standard governing claims of harmless error, and we remand to the Fifth Circuit to apply the standard in the first instance. I'm going to read that again. With respect to the FDA's guidance on marketing plans, we clarify the appropriate legal standard governing claims of harmless error, and we remand to the Fifth Circuit to apply that standard in the first instance. So whether their change in position on marketing plans, where they in the end said we're not going to review these marketing plans, even though they called for them in the first place, whether that is harmless error. And they are clarifying the appropriate standard of harmless error for the Fifth Circuit to apply in the first instance. We begin with our change in position doctrine. The APA requires a reviewing court to hold unlawful and set aside agency action found to be arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law. Our well-worn arbitrary and capricious standard ensures that an administrative agency examined the relevant data and articulated a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. Blah, 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 blah. The essence of respondents' argument is that the FDA told them in guidance documents that it would do one thing and then turned around and did something different when it reviewed their applications. The change in position doctrine is administrative law's answer to that problem. Under that doctrine, agencies are free to change their existing policies as long as they provide a reasoned explanation for the change, display awareness that they are changing position, and consider serious reliance interests. For reasons we explained, the change of position doctrine provides the governing framework here. The change of position doctrine asks two questions. The first is whether an agency changed existing policy, and we have suggested that this occurs when an agency acts inconsistently with an earlier position. Echoing the Fifth Circuit, respondents claim that the FDA violated the change in position doctrine with respect to the four principal themes discussed above. First, according to respondents, the FDA, after initially telling applicants that no specific kinds of scientific evidence were required, turned around and rejected all applications lacking evidence from a randomized controlled trial or longitudinal cohort study. Second, respondents claim the FDA told the applicants that they had discretion to choose appropriate comparative products, but it ultimately denied applications on the ground that they failed to make specific comparisons between dessert, candy, and fruit-flavored products on the one hand and tobacco-flavored products on the other. These are all their arguments for how the FDA violated the change of position doctrine. As to the first three issues, we conclude that the FDA's denial orders were sufficiently consistent with its pre-decisional guidance and thus did not run afoul of the change in position doctrine. Now we're only looking as to the failure to consider the marketing plans. The FDA does not seek review of the Fifth Circuit's finding of error. Rather, it asks us to clarify the harmless error rule and remand for application of the proper standard. We agree with the FDA that this is the appropriate course of action. So this tobacco making product company, somebody asked for the case name. It is Food and Drug Administration v. Wages and White Lion Investments. The tobacco company threw a lot of arguments at the wall here for how the FDA violated the change of position doctrine, acted arbitrarily and capriciously. The court rejects 3 out of the 4 with respect to 1, which is whether these tobacco companies trying to bring these e-cigarette products to market, they were told they needed to provide marketing plans, in part because they were concerned about these e-cigarette products being marketed to youth. But then they said, actually, we're not going to require these marketing plans and consider them when we're denying or approving your application. So that switcheroo, does that violate the APA, the change of position doctrine? And so what the court is doing is clarifying the legal standard and sending it back to the lower court to figure out whether it was a harmless error, their change of position on the marketing plans, or whether that substantively affects the applicant's rights here and that they violated the APA. So 2 decisions from the Supreme Court today. Wow, it is already 10:30. We just read a lot of the APA decision, I know. 2 decisions from the Supreme Court today. The first is about the truck driver who took CBD and was told there was no THC, but turns out there was, and got drug tested and got fired. He gets to pursue a civil RICO claim against the company, arguing that they were acting as this enterprise. And that means he can try to pursue triple damages. It's still going to be a long road for him, but he at least gets to pursue the claim. And then we got the flavored e-cigarettes case where the court rejected the majority of the challenges to the FDA's actions, but left open clarification for one of them and whether they violated the APA, the change of position, acted arbitrarily and capriciously when they said, hey, you need to show us your marketing products. We're bringing e-cigarette vapes to market. And then they said, actually, we're not going to review your marketing products. So that is the finding. Yes, Marley, we got the SIR reply this morning in the JGG El Salvador case, so the court can decide the emergency request at any time. Right now, it's just in an emergency posture at the court. So we could get that this afternoon. No, those are the final 2 decisions. I definitely have to go. I will make a TikTok later. I'll do a quick summary one now, and then we can get more in depth later. Thank you all for joining, and I will see you next time we have an opinion day. Happy Wednesday. Today's Wednesday. Happy Wednesday. Bye, guys.